Hello students, welcome to AKS. We'll continue our discussion on fundamental rights. We will now deal with right against exploitation. What are the various rights against exploitation is what we will discuss in this video. So basically the rights against exploitation are mentioned under Article 23 and Article 22, 24 of the Constitution. So these are the rights against exploitation. Now let us look into Article 23 of the Constitution. What does it say? Article 23 says that the state is to prohibit trafficking in human beings and forced labor. That is, what is trafficking? It is using humans for commercial purposes like sex trade, purchase and sale of human beings. Okay, what is begar or forced labor? It is compulsory work without remuneration. Forced labor is nothing but compelling a person to work against his own will. So to bring effect to this article, the government in the year 1976 passed the Separation of Immoral Trafficking Act, that is the CETA Act, and then in the year 1978 it brought about Bonded Labor System Abolition Act. So Article 23 says that the state is to prohibit trafficking in human beings, and forced labor. Okay. Then what are the limitations under this article? By Article 23, the state is given the power to pass a law to impose compulsory service for a public purpose. For example, whenever there's a public purpose or larger public interest at requirement, then the state can impose compulsory service, like this section of the society has to work. But apart from that, there shall not be any trafficking and forced labor. Now let us look at Article 24. Article 24 says that no child below the age of 14 years will be employed in factories, mines, and hazardous occupations. The Government of India passed Child Labour Prohibition Act and Regulation Act of 1986. The Schedule 2 consisted of a list of hazardous works. In the year 2012, in the month of August, the Schedule 2 of the Act was repealed. This paved the way for complete abolition of child labor in any form, that is both hazardous and non-hazardous works. Recently, there has been some changes in this article as well that we will discuss in due course of time. So this is against child labor, okay? Article 24, that is what you have to remember. Then let's move to the next important part of fundamental rights, that is right to religious freedoms. Right to religious freedoms. Under Article 25 to 28. So these are the right to religious freedom. Article 25. Article 25 of the Constitution guarantees the right to conscience. The right to conscience. Then it also guarantees the right to practice, propagate, and profess. The right to practice, propagate, and profess any religion of your choice. This is available to both citizens and non-citizens. The right to conscience, religious conscience, the right to practice, profess, and propagate any religion of this choice. The Supreme Court declared that the fundamental right to propagate religion does not necessarily allow the right to convert other person forcibly into one's religion. Odisha is the first state to pass a law prohibiting forcible conversions. Article 25 protects religious rights of individuals. However, Article 26 protects the religious rights of religious denominations or religious sections, that is collective freedom of religion. What are the limitations under Article 25? Article 25 states that the state may regulate the economic, financial, and political activities associated with the religion. For example, under the Endowments Act, a public place of worship can be brought under the Act so that the state can use the finances, economic as well as political activities of that particular place of worship for public welfare. Number two, the state has the power to regulate the religious activities on the grounds of public order, morality, and public health. Okay. Then the state is to see that all public places of worship of Hindus should be open to all classes of Hindus, because earlier certain places of worship were restricted. Okay, the backward castes or the Dalits and other castes were not allowed into Hindu temples. So Article 25 states that the state states that all places of public worship shall be open to all classes of Hindus, all classes and castes of Hindus. Then let us look at Article 26. Article 26 of the Constitution. Article 26 of the Constitution states that every religious group has the right to establish, administer, and maintain religious institutions and charitable organizations. So this deals with religious groups. Okay, the institution can acquire movable and immovable properties and administer the same. This means that religious and charitable institutions still have the right to property. However, the limitations on this are the state can regulate the activities of such institutions or religious organizations on the ground of public order, morality, and health. Having discussed about Article 26, now let us discuss about Article 27 of the Constitution. Article 27 of the Constitution says that no person will be compelled to pay taxes whose monies will be used for promoting and maintaining a particular religion. Okay, no person shall be compelled to pay taxes for the maintenance of any particular religion only. Okay. Article 28. Now, let us look at Article 28. Article 28 states that this Article 28 is about secularism. Secularism means public education should be free from the influence of religious teachers and teachings, one of the paradigm of secularism. So, this guarantees the right not to attend any religious instruction. No religious teaching shall be provided in any educational institution wholly run by the state. Article 28 states that no religious instruction shall be provided in any educational institution wholly run by the state. What are the exceptions to this? Educational institutions receiving aid from the state, religious teachings can be provided, but with the consent of the student or the guardian. Okay. So those institutions, those religious institutions which are receiving aid from the state, they can provide religious teaching, given that there should be consent from the student or the guardian. Next, educational institutions set up by an endowment or a trust but are being administered by the state. In such institutions, religious teaching can be provided. Okay. For example, the Tirumala Tirupati Devasthanam, etc. So it can be said that Article 25 to 28 are secular rights, wherein the state will not show patronage to any religion. That is the secularism of India. That is, the governance should be free from the influence of religion. The state will treat all religions equally. That is our way of secularism. Then you have articles, Article 29 and 30. Article 29 and 30, these are cultural and educational rights. Cultural and educational rights. What does Article 29 say? Article 29 states that citizens who are residents of India who have a distinct language, script, and culture of their own have the right to preserve and protect it. No citizen shall be denied admission into an educational institution maintained by the state and receiving aid from the state on grounds only of religion, race, caste, sex, or region. So, this Article 29 has two paradigms. One is the right to protect and preserve their distinct language, culture, script. Okay. And next, no citizen shall be denied admission into an educational institution maintained by the state or receiving aid from the state government on grounds only of religion, race, caste, region, or sex. However, unaided institutions can have admission their own admission policy. Having discussed about Article 29, now let us discuss about Article 30. This is the only article that defines minorities. All minorities, whether based on language or religion, all minorities, whether based on language or religion, have the right to establish, administer, and maintain educational institutions of their choice. They have the right to establish, administer, and maintain educational institutions of their choice. The state will not discriminate against these institutions while granting aid to them. Okay, if the state acquires the property of such institutions, it will give compensation for the same. Okay, that is in Article 25. If you see, there is no compensationary right, but over here, if the state acquires the property of such religious institutions or that minority institutions, whether they are linguistic or religious minorities, it will give compensation for them. The state will not discriminate against these institutions, and these institutions have the right to administer, establish, and maintain educational institutions. This means that the fundamental right to property is available to educational institutions set up by minorities. This means that the fundamental right to compensation is available to these educational institutions set up by minorities, whether religious or linguistic. Having discussed about this, now let us try to understand this term called eminent domain. Eminent domain is the right of the state to acquire private property for public purpose. Acquire private property for public purpose. For example, the Land Acquisition Act of 1984. Okay, so these are some of the activities that the government can take under the eminent domain concept for larger public interest. So under Article 30, you also have one of the right. The state has a right to regulate the administrative matters of such educational institutions run by minorities. Okay, whenever there is an issue regarding the administrative matters, not the religious matters, the state can regulate these activities. Under the TMA Pai Foundation case 2002, the Supreme Court of India ruled that linguistic and religious minorities can be determined by using state as a unit. Linguistic and religious minorities can be determined by using state as a unit, not the national level. Supreme Court declared that Article 19(1)(g), which gives the freedom to practice any profession and occupation of choice and set up educational institutions. In all educational institutions, including minority educational institutions, admissions have to be based on common interest test. In minority educational institutions, the state cannot impose the policy of reservation to SCs, STs, and OBCs. Also, professional educational institutions cannot charge capitation fee or donations. So these are some of the observations that the Supreme Court had made in the TMA Pai Foundation case of 2002. So having discussed about Article 29 and 30, let us move to Article 31 of the Constitution. Article 31 of the Constitution. So actually Article 31 and Article 19(1)(f) of the Constitution have been repealed. Okay, why and what we will discuss. What does this Article 31 state? All citizens of India will have the fundamental right to property and compensation. Article 19(1)(f) said that the people in India will have the freedom to acquire, hold, dispose, movable and immovable property throughout India. So both these articles, Article 31 and Article 19(1)(f), have been removed or repealed. Okay. That is a right to property, and the compensation for the same has been repealed as a fundamental right. By the 44th Constitutional Amendment Act of 1978, it deleted Article 31 and 19(1)(f) by the 44th Constitutional Amendment Act. Then Article 300A. Article 300A, what does it state? Has been introduced, which states the right to property is not a fundamental right, but is only a constitutional right. That is, which can be amended and may be taken away by the ordinary law of the parliament. It does not require any constitutional amendment act. The compensation that has to be provided by will be determined by the state. It is not a fundamental right. Also, inadequate compensation given by the state cannot be challenged, but it is mandatory for the state to provide compensation according to market prices. Then Article 31A was introduced. by the first Constitutional Amendment Act, which declares laws for the acquisition of private property will not be deemed as ultra vires. When the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limit, then the state has to pay compensation at market value. Article 31A does not immunize a state law from judicial review unless it is reserved for presidential consideration and has received his assent. Article 31A was introduced by the first Constitutional Amendment Act, which declares laws for the acquisition of private property will not be deemed as ultra vires of the Constitution. Then Article 31B was introduced by the 24th Constitutional Amendment Act 1971. It has created the ninth schedule to the Constitution. What is ninth schedule? That is, whatever laws which are framed under ninth schedule are saved from judicial review. So that was a procedure then. Later on, it had changed. In the year 2007, the Supreme Court said that judicial review is a basic feature of the Constitution, and laws made by the Parliament after the Kesavananda Bharati case of 24th April 1973 are open for judicial review. So before 2007, laws made by the state legislature and Parliament, if they are put in the seventh schedule, they will be immune from judicial scrutiny. There will not be any judicial review. Then Article 31C was introduced, which gave precedence to the directive principles of the state policy for the first time in independent India's constitutional working. Article 31C was introduced. Article 31C was introduced by 25th Constitutional Amendment Act 1971, which states that laws that seeks to implement directive principles of state policy under Article 39B and Article 39C will not be unconstitutional even if they violate Article 14 and Article 19 and will be open for judicial review. I repeat, under Article 31C, laws that seek to implement directive principles of state policy under Article 39B and Article 39C, which we will try to read about in the later lectures, these laws which seek to implement the socialistic principles will not be unconstitutional even if they violate Article 14, that is a right to equality and right to freedom, under Article 19 and will be open for judicial review. Then let us discuss about Article 32. Under Article 32, the right to constitutional remedies is being provided. So it provides for judicial review power. Article 32 gives the power to the courts for judicial review. That is, remedy will be in the form of writs enforced by the courts, usually the Supreme Courts. The writs are called as privileged or prerogative writs. Prerogative writs can only be issued by the Supreme Court. The citizens can seek the various writs can seek the enforcement of various writs from the Supreme Court. For example, number one, the writ of habeas corpus. What does this mean? Produce the body, or where is the body? Habeas corpus in the literal sense of the term means where is the body? The court will ask the executive or the police to produce the detained person before the court. If the court finds the detention as illegal, then it can relieve the person and guarantee Article 21 of the Constitution. Another writ, next writ is mandamus. It is issued by the Supreme Court to execute public office, to the executive or public officer to perform the duties of public office. The limitations of this are the writ of mandamus cannot be issued to the President of India or the governor or the parliament and the state legislature. This is issued by the Supreme Court to the executive or public officer to perform his duties, mandamus, perform. However, this cannot be issued to the president, governor, parliament, and state legislatures because these are highest constitutional and legislative organs. Legislatures are not issued mandamus due to the separation of powers between the legislative, executive, and judiciary. Then you have another writ called certiorari. This can be issued by a Supreme Court to an inferior court. The superior court gives a writ of certiorari, which nullifies the judgment of an inferior court which has overstepped its jurisdiction. It is a curative writ. The superior court can quash the order of the inferior court and can now take up the matter into its jurisdiction and issue a new order. Prohibition. Next is prohibition. The next writ is prohibition. There are 6 writs. Okay, we have discussed about 4. Now let us discuss about prohibition. This is issued by the Supreme Court to the this is issued by the Superior Court to the Inferior Court, so that the lower court is not going ahead with the trial. Before the judgment is passed itself, the Supreme Court takes up the case, or the Superior Court takes up the case, and thus it is called as a preventive writ. Preventive writ. Certiorari is curative. After the order is passed, then the Superior Court takes up. Here, before the order is passed only, it takes up. That is why it is preventive. Then the next writ is quo warranto, QUO warranto. What are the legal grounds and the basis on which a person is eligible to occupy public office will be determined by the court. In the literal sense, quo warranto means what is your authority to occupy this office. So these writs are guaranteed under Article 32, and the High Court under Article 226, under Article 226, which we already discussed. High Court under Article 226 guarantees the enforcement of these writs. This is the writ jurisdiction of the Supreme Court and the High Court. Okay, having discussed about this, now let us discuss about Article 33. Article 33 of the Constitution. It gives the Parliament, the power to make laws. So Article 33 gives the Parliament the power to make laws, either to declare that some fundamental rights are not available, or are available with some restrictions, or some fundamental rights are not available to some classes of services, such as the officers responsible for maintaining public order, like at the police. Okay, some fundamental rights are available in limited quantity or with some limitations to them. Then some officers who are all members of the armed forces. Then all members who are members of the intelligence agencies. Intel agencies are the government of India or the state government. Then members of telecom agencies working for armed forces and for intelligence agencies of forces responsible for maintenance of public order. Now let us discuss about Article 34. It states that the Parliament can always pass a law to indemnify, that is providing legal immunity to government servants and members of the armed forces for all the acts they have done or committed in the region under temporary martial law. Okay, as part of their public duty. During their public duty, if they have performed any acts, they are legally indemnified. Okay, for example, when there is a Armed Forces Special Powers Act or Disturbed Areas Act, in such an area, there is legal immunity to these armed forces. For a particular region to be brought under martial law, no proclamation is required. For a region under internal rebellion, automatically martial law will come into force. So please don't confuse martial law with what do you call as national emergency. Okay, we will discuss about this in detail when we discuss about the chapter called emergency provisions. Now let us discuss about Article 35. Article 35 states that Parliament has the power to make laws to give effect to some fundamental rights. This has also mentioned under Article 35. Parliament has the power to make laws to give effect to some fundamental rights. For example, Article 16, which we discussed, prescribes residence within a state or union territory can be imposed as an eligibility condition for some category of posts under the order of the government of state or the union territory. Also under Article 33 and 34, and also Article 32 Clause 3 can be brought to effect. So Article 32 Clause 3, Parliament under its law can give writ jurisdiction to any courts other than the High Court and the Supreme Court. So like this, various articles, various fundamental rights can be brought to force through this Article 35. That is, Parliament has the power to make laws to give effect to some fundamental rights under Article 35. So that brings an end to our discussion of a brief overview about fundamental rights. In the next video, we will discuss about the directive principles of state policy under Part 4 of the Constitution. Thank you. Have a good day.